He has never been part of our financial decisions, my brother's wife said. She didn't raise her voice. She didn't need to. She said it the way someone states a fact about whether flat, already settled, not particularly interested in a response. He has always been too removed, too detached to engage. For years this family has worked around that, and frankly, it is time someone said it plainly. The mediator, a man named Norman Hatch, mid-60s, silver-framed glasses, the unhurried stillness of someone who had listened to families disassemble themselves across conference tables for a very long time, let a moment pass before he responded. He had a yellow legal pad in front of him. He hadn't written on it in some time. "Mr. Caldwell," he said, addressing my attorney rather than my brother's wife, rather than me. "Before we continue with the asset review, I'd like a clarifying question answered." A pause. "Has your client had the opportunity to review the professional background of the gentleman seated across from her?" My brother's attorney, a younger man named Selden who carried himself like someone still establishing that he belonged in the room, glanced briefly at the folder in front of him. "He's retired," he said. "Technical background of some kind. Engineering, I believe." Norman Hatch set his pen down. "Some kind." The conference room on the 9th floor of the Mercer Building in Columbus, Ohio held 6 people that afternoon. For one long moment, 5 of them went very still. "My name is Nathan Ware. I am 62 years old. I spent 31 years as a forensic structural engineer, first with a federal infrastructure oversight office in Washington, then independently, contracted by insurance carriers, legal teams, and municipal agencies that needed someone to examine structures with the kind of attention that finds what standard inspection misses. My work was about reading what built systems were designed to conceal. I was patient. I was methodical. I testified as an expert witness in 38 proceedings across 7 states. My brother had known this the same way he knew my shoe size, as a detail that had stopped functioning as information. I sat across the table with my hands flat on the surface and said nothing. I had learned this 30 years ago. When someone is characterizing you inaccurately, the most important thing you can do is give them room to finish. 6 weeks before that meeting, my mother had died. She was 81 years old. She had lived in the house in Lancaster, where my brother and I grew up until her memory began failing her in the last 3 years of her life. At that point, my brother and his wife had stepped in, practically, visibly, in the way that earns gratitude without demanding it. They drove to Lancaster twice a week. They managed her medical appointments. They helped her sort through correspondence from her bank, her insurance carrier, the facility that eventually became her part-time care arrangement. My mother trusted them. She trusted my brother because he was her son, and she trusted his wife because she had known her for 26 years and because her own fatigue had narrowed the world to what was directly in front of her. I live in Dayton, 45 minutes from Lancaster. I visited when I could, which was often, though never as often as I told myself it would be. My wife passed 8 years ago. I had retired 3 years before my mother's decline began, and my days had the particular shape of a man who had chosen solitude without entirely intending to. I read. I took on occasional consulting work. I drove on Saturday mornings without fixed destinations. My brother and I had never been close in the way that people talk about brothers being close. We were cordial. We appeared at the same occasions. We agreed on the things that didn't require agreement and avoided the ones that did. His wife had a position on everything, and stated each one with the certainty of someone who had never seriously entertained the possibility of being wrong. I had stopped engaging with her on anything substantive somewhere around the middle of the previous decade. What I did not know, not clearly, not provably, was what had been happening in my mother's finances during the 2 years before her death. I had suspicions, small things. A comment my mother made in passing about feeling confused by paperwork she thought she had already understood. A phone call in which she mentioned, with a tone that didn't match her words, something she called the account the kids set up. The way my brother's wife had begun referring to my mother's property as though its disposition was already determined, in conversations that had reached me sideways, embedded in other subjects, in moments where I hadn't been present for the original discussion. I noticed these things. I said nothing. I had spent my career knowing the difference between a pattern and a conclusion. My mother died on a Wednesday morning in February. I was with her. She had been a composed woman her entire life, and she was composed at the end of it, a lamp dimming, not switching off. The documents arrived 4 weeks later, not from a court, from my brother's attorney's office, a package requesting my signature on what was described as a routine estate settlement agreement. The language, when I read it carefully, and I read it 3 times, was designed to accomplish 2 things simultaneously. appear to be a formality while functioning as a release of liability for the entire period of my brother's oversight of my mother's financial affairs. Every transaction made during the 2 years he held power of attorney would be ratified by my signature. Every account movement, every third-party arrangement, every decision made while my mother was alive, but no longer fully able to question what she was signing. I set the papers down on the kitchen table. I made a cup of coffee. I sat there for a long time, not thinking about anger, thinking about sequence. In structural engineering, you learn early that a building doesn't collapse because one thing failed. It collapses because several things failed quietly, over time in a specific order. You find the failure not by examining the wreckage, but by reading the original design. My mother's original design was something I knew well. The next morning, I drove to Lancaster. My mother's house had the particular stillness of a place that had been lived in completely and then stopped. Her reading glasses sat on the side table next to her chair. A newspaper from 2 weeks before her final care stay was still folded on the kitchen counter. She had been a woman of careful order, and the order remained, suspended, like a sentence broken mid-word. I went to the cedar chest at the foot of her bed first. She had kept documents there since before I was born, organized by year in the way of someone who had grown up understanding that paper was a form of protection. The pattern in the older files was exactly what I expected: consistent, modest, the financial behavior of a schoolteacher who had raised 2 children on a single income and treated what she had with deliberate respect. Then, starting approximately 24 months before her death, the pattern changed. New account numbers appeared in correspondence. Withdrawal records showed transfers to an entity listed as Caldwell Family Advisory, LLC, a name I had never heard. A letter from her primary bank referenced an amendment to her trust structure that I had no record of. Several documents had been refiled out of their original sequence, which my mother would not have done. Order was not a habit for her. It was a conviction. I photographed everything without moving anything. There was a second location. My mother had kept a lockbox on the shelf in her hall closet, pushed to the back, behind the folded winter blankets where the wall met the ceiling. She had shown it to me once, years ago, not to reveal the contents but to make sure I knew where to look. In case, she had said. Nothing else. She was that kind of woman. She prepared for contingencies without dramatizing them. The key was in a small ceramic dish in her jewelry drawer, underneath a string of pearls she wore only to weddings and funerals. Inside the lockbox were 3 items: the original deed to a small rental property she had owned since the early 90s, a sealed envelope with my name on it in her handwriting, and a USB drive with a strip of tape across the top that read, in her careful print, "For Nathan, the copies." I sat down on the closet floor with the envelope in my hands and held it for a while before I opened it. My mother's handwriting had changed, the letters uneven, the pressure inconsistent in a way that marked the Parkinson's that had arrived alongside the memory difficulties. But the words were entirely hers. She had written 4 pages. She wrote that she had become confused about the accounts, that things had been explained to her in ways that made sense in the moment, and then stopped making sense when she tried to recall them afterward. She named specific dates on which she had signed documents she hadn't fully understood, and said that when she later asked to see copies, she was told the paperwork was being stored for her convenience. She wrote that she had asked her neighbor, a woman who had lived 2 houses down for 30 years, to drive her to the library and help her use the document scanner to copy what she could still locate. She wrote that she didn't want to accuse anyone of anything wrong. She wrote that she didn't know exactly what the trouble was, only that something felt wrong, and that she was tired and frightened, and she wanted me to have the information in case it mattered later. At the end she wrote, "You've always been the one who knows how to read things. I watched you do it your whole life. I trust you to see this clearly." I sat in that closet for a long time. The house was completely quiet. I could hear the porch light timer clicking in the front hallway. When I left, I took the envelope, the lockbox, and the USB drive. I left everything in the cedar chest exactly as I had found it. That afternoon, I called an attorney named Janet Colby. I had worked alongside her on a deposition 4 years earlier involving disputed infrastructure documents in a municipal contract case. She was precise in the way that genuinely useful people are precise, not performative about it, simply accurate consistently. She had moved into estate litigation recently, and from what I knew of her, she brought the same quality to it. She listened without interrupting. When I finished, she was quiet for a moment. "They requested your signature rather than going through probate court," she said. "Yes." "That's instructive," she said. "If the transactions were defensible, they'd want the court's formal review. The signature route bypasses scrutiny. They expected you to sign because they expected you to grieve and not look closely. She explained what a properly contested estate dispute looks like when built correctly. The power of attorney could be examined for the circumstances of its execution. The LLC could be subpoenaed for operating records and licensure documentation. Banks cooperate readily when the paperwork comes from the right direction. And the USB drive my mother had prepared. Janet paused here, and the pause had something almost like professional recognition in it. It was not a minor piece of evidence. "What outcome do you want?" she asked. I thought about my mother's handwriting, the uneven letters, the ceramic dish. The fact that she had prepared for this while she was frightened and exhausted and still more worried about being fair than about being right. "I want the record to be accurate," I said, "without me having to make it a spectacle." "Then we build the record quietly," she said, "and let the hearing do the announcing. Can you live inside their version of you for a few weeks?" I told her I had been practicing patience for most of my adult life. This would not be the most demanding version of it. For the 3 weeks that followed, I lived carefully inside the frame they had built. I replied to my brother's messages in short, subdued sentences. When his wife called once to check in, a call that had the texture of surveillance dressed as warmth, I answered briefly and let her draw the conclusions she needed. When Selden's office sent a follow-up about the settlement documents, I wrote back that I was still reviewing them and asked for more time, which they granted readily. People who believe they are winning do not rush. I noticed my brother's posture ease at a family gathering 10 days before the mediation. He believed the weight was working in his favor. He was right about that, just not about which direction. Janet worked methodically through proper channels. She filed a records request with my mother's bank, citing the pending estate dispute. She retained a forensic accountant to examine the Caldwell family advisory transactions, the timing, the amounts, the account structure. She located my mother's neighbor and took a formal statement. The neighbor remembered the visits to the library. She remembered my mother's worry. She remembered the specific afternoon, the date, the documents my mother had been carrying in a manila folder. And then Janet found what the LLC actually was. Caldwell Family Advisory had been set up and managed through a woman named Terry Bloom, who ran a small bookkeeping and financial services business out of Westerville. She was not a licensed estate attorney. She was not a licensed financial advisor of any kind. Her credentials were in basic accounting, and the documentation she had produced for the transactions she processed was categorically insufficient for estate work of this scale and complexity. When the state's Financial Regulatory Office received an inquiry through the proper channel, they opened a compliance review within 8 days. Terry Bloom retained counsel the morning after she was contacted. I noted that response and understood precisely what it meant. The night before the mediation, I drove to Lancaster. I didn't go inside. I sat in the car along the curb and looked at the porch light, the one my mother had kept on a timer every evening since my father died in 1998, a habit she had kept so long it had become part of the house's character. I thought about her at the library, with her neighbor, the manila folder in her hands, worried and careful, and still doing the work of protecting something she wanted to leave intact. She had known something was wrong. She had done what she could. She had left what there was to leave. In the conference room the following afternoon, when my brother's wife said what she said and Selden confirmed the version they had constructed, I stayed still. When Norman Hatch asked his question and the room went quiet, I understood that we had arrived at the place my mother had been preparing for, the point where the careful work begins to speak for itself. Janet rose without urgency. She rested one hand on the edge of the table and addressed Norman Hatch with the level confidence of someone who has nothing to establish. "The settlement documents in this mediation," she said, "request my client's ratification of financial decisions made during his mother's final 2 years. What we intend to demonstrate is that those decisions were made without transparent accounting, through an unlicensed intermediary, under a power of attorney executed during a period the client's own mother documented, in writing, as one of significant cognitive confusion." She began with the timeline. Account statements appeared on the screen at the end of the table. The consistent years set beside the inflection point, the month the power of attorney was signed, the moment new entities appeared and the character of the transactions changed. Selden objected twice. Norman Hatch addressed the first with a question and dismissed the second before it finished. Janet moved to the power of attorney itself. She did not use the word fraudulent. She used the phrase executed under circumstances the law examines closely, and she supported that phrase with a letter from my mother's primary care physician, documenting that in the month the document was signed, My mother had exhibited significant short-term memory disruption and had required repeated explanations of routine procedures during office visits. Not incompetence, Janet said, but a window of documented vulnerability that the law does not treat as incidental. She presented the Caldwell family advisory material, the regulatory inquiry, the licensing gap, Terry Bloom's retention of counsel, and the meaning of those facts beside the transaction record. My brother had been sitting very still. His wife's posture had shifted in the way of someone whose plan has been read aloud and found to be simpler than she believed it was. Then Janet placed my mother's letter in front of Norman Hatch. She did not read it in full. She noted its date, its existence, the lockbox, the ceramic dish, the USB drive with its strip of tape. She read 3 sentences, the 3 we had selected the evening before, the 3 that carried weight without requiring drama. The room was quiet in a specific way, not the quiet of people waiting. The quiet of people listening to something they had not expected to hear. Norman Hatch read the letter himself without rushing. When he set it down, he folded his hands and turned to me. "Mr. Ware," he said, "I'd like to ask you something directly." "Of course," I said. "Your professional background. Can you describe it for the record?" I had spent 31 years in forensic structural engineering, I told him. Federal oversight work to begin with, then private consulting. My work involved identifying failure patterns in built systems, places where structures had been designed or modified in ways that created risk that did not surface under normal conditions. I had testified as an expert witness in 38 proceedings across 7 states. Norman Hatch looked at me over his glasses. 38. "Give or take," I said. He turned to Selden. "This background was not part of your client's characterization of her brother-in-law's capacity to evaluate estate documents." Selden paused in the particular way of someone recalculating from the beginning. "We understood his background to be technical in nature. We believed the relevant question was his current engagement with." "Technical," Norman Hatch said. My brother's wife stood up. Her voice had an edge in it that I recognized, the edge that appears when the room stops agreeing with what she has said. "He has been retired for 3 years," she said. "He has no involvement in this family's affairs. He has never wanted involvement. He has always kept himself at a distance and called it consideration. And now because our mother left things to him and he can't accept that we were the ones who were actually there." "Mrs. Ware," Norman Hatch said, using her married name with the precise quietness of someone who uses names deliberately, "please sit down." She sat. Her jaw was tight. "Counselor," he said to Janet. Janet continued as though there had been no interruption. She presented the contents of the USB drive, the copies my mother had made with her neighbor's help, receipts, statements, a handwritten inventory my mother had attempted of what she still had access to, dated in her own hand, clearly the work of a woman who was frightened and was doing the most she could with what she had. And then Janet placed one additional document before the mediator. The deed to the rental property in Lancaster, which, according to a transfer record included in the documents my mother had copied, had been conveyed from her name to Caldwell Family Advisory LLC 17 months before her death, for a stated consideration significantly below current market value, executed on a date that my mother's care notes documented as one of her more difficult cognitive days. Norman Hatch studied the document. He turned it over. He set it down flat on the table. He looked at it for a moment, then looked at the room. "I am declining to ratify the settlement agreement," he said, "and based on the materials presented and the ongoing regulatory review now on record, I am referring this matter to the County Prosecutor's Office for review of the transactions in question and the conduct of Caldwell Family Advisory, LLC." My brother looked at his hands. His wife stared at a point somewhere above the window. Neither of them said anything. Outside, Janet walked with me to the elevator. The building's air system hummed overhead. She said what she said after proceedings like this: "This part is over. The longer part comes next," and I told her I was accustomed to longer. The consequences arrived in pieces, which is how consequences usually arrive in serious cases. The rental property transfer was unwound following the prosecutor's review. The transaction documentation was found insufficient, and the discrepancy in consideration amount significant enough to void the conveyance. Terry Bloom cooperated with the investigation in exchange for reduced exposure. My brother issued a statement through his own attorney, distancing himself from specific decisions, which I neither accepted nor disputed. His wife accepted a settlement agreement that included full restitution, a permanent prohibition from serving as a financial representative for any other person, and 3 years of supervised probation. She communicated with me once through her attorney. The message said I had manufactured this outcome and that what I had done to the family could not be undone. I read it once, set my phone on the counter, and decided that some communications don't require a response. They require distance and time, and the recognition that the kind of closure that arrives in a final letter is rarely the kind that holds. My brother called 6 weeks after the settlement. His voice had the careful quality that voices acquire after certainty has been removed. He said he had believed what he had been told for a long time about many things. He said he wasn't sure how to begin. I told him the beginning didn't have to be large. I told him I was not going anywhere, and that if he wanted to understand what had happened, the county clerk had the filed record, and he could read it at whatever pace suited him. He was quiet for a moment. Then he said, "She always said you were the one who stayed on the outside, that you never really wanted to be part of things." "I know," I said. He took a breath. "Was that true?" I thought about the cedar chest, the ceramic dish, the library scanner, and a woman in her 80s who was frightened and wanted her son to be able to see clearly when the time came. "I was paying attention," I said. "I didn't announce it. Those aren't the same thing." He didn't respond right away then. "I don't know what I owe you." "Nothing," I said. "You don't owe me anything. You came back. That's the beginning." We spoke for a little while longer about ordinary things. It was not a resolution. It was an opening a small door left unlocked, which is sometimes all you can ask of a conversation. My daughter called 3 days later. She lived in Pittsburgh and had seen the public filing. Her voice was steadier than my brother's, which was characteristic of her. She had always moved through facts before feelings, a quality I had recognized in her from the time she was very young. "I need to say something," she said. "I've been thinking about how to say it." "Go ahead," I said. I should have asked more questions. "In those last months with Grandma, you mentioned a couple of things that I filed away." I told myself I didn't want to cause trouble in the family. I chose quiet over honest. "You didn't have enough information," I said. "I had enough to ask more questions," she said. "That's different." She was right. I told her so. I also told her that I hadn't said enough either, for most of a lifetime, and that there were two of us arriving at the same understanding from different directions. She was quiet for a moment. "Did she know you'd find it? The letter? Everything?" I thought about my mother's careful hands. The ceramic dish. The strip of tape on the USB drive. A woman who had spent 32 years teaching children how to leave a record of their thinking so someone else could follow it. She built a system, I said. She made it as clear as she could. Whether she believed it would reach me, I think she trusted the structure she'd built. She was always good at that. My daughter made a sound that was almost a laugh, and almost something else. "That sounds exactly like her." "It does," I agreed. She flew out the following month. We spent a Saturday afternoon going through the things that had come to me as part of the estate. Small objects, a box of photographs, the reading glasses I still hadn't been able to move from her side table. My daughter held each thing for a moment before setting it down. She asked questions about some and said nothing about others, and that felt exactly right. Before she left, she stood in the kitchen doorway. "I want to do better," she said, "about staying in touch, about being actually present." "So do I said. She nodded. That was enough. It didn't need to be anything more than what it was. I sold my mother's house in Lancaster the following autumn. On the last day before closing, I walked through it one more time. The cedar chest had been removed, the closet cleared, the surfaces cleaned and staged for the next person. It smelled like fresh paint and an absence that was not quite like any other absence I had known. Not her. I stood in the bedroom for a while where the chest had been, where I had found the ceramic dish and the key and the letter in the USB drive with its hand-labeled tape. Before I left, I took my mother's letter from my coat pocket. I had carried it with me since the afternoon I found it, folded in the inner pocket, and I stood at the kitchen window where she used to open her mail on Saturday mornings, and I read the last part one more time. "You've always been the one who knows how to read things. I trust you to see this clearly." I folded it and put it back. I stood on the porch in the October air for a moment before I walked to the car, and I let myself feel what I had been too careful to feel for a long time. Not triumph, not even relief exactly. Something quieter, the specific settledness of having done the thing you were built to do, in the only way you knew how to do it, because someone who loved you believed you were capable of it. The final document arrived from the county clerk's office 3 months later. Estate of Eleanor Marie Ware, closed. Restitution complete. I set it on the kitchen table next to a cup of coffee that had gone cold while I was reading, and I looked at it for a while without picking it up. My mother used to say that the most important records are the ones nobody thinks to question. She said it about student work, about the papers at the bottom of the stack that got marked average because no one looked past the ones on top. She said it once, the way she said everything she meant, plainly, without repeating herself, with the quiet assumption that you had heard her and that hearing was sufficient. She was right. The records at the bottom of the stack don't rewrite themselves to protect anyone. They hold what happened in the original handwriting, and they wait, patient as anything, for someone who knows what they are looking at. I have spent my life being that person. It is not a visible thing to be. It rarely announces itself, but it is useful in the end in the way that anything built without ceremony tends to be useful, steadily when it counts, and long after the moment has passed when anyone else thought to look. I pushed back from the table and stood up slowly, the way you do when 62 years have given your joints their own opinions about pace. I carried my coffee to the window and stood there for a while, watching nothing in particular. The neighbor's maple had dropped most of its leaves. A car moved slowly down the street and turned the corner and was gone. If you have ever been the quiet one, the one who sees things and says nothing, who gets called absent when you were actually just still, I want to hear from you. Tell me where you're listening from. Tell me what time it is where you are. These are the stories worth carrying, and I have more of them.